Well, nothing like having another English speaker at the end of the day and an attorney on top of that. You know, we're not the most exciting people. So I am going to try to make it a little bit of exciting. Let me tell you a little bit about myself to start with, just so you know. You're probably thinking, why is an American up here talking to me about data privacy and data sovereignty laws, given the fact that the US has the least restrictive and what I call non-existent data privacy laws? I'm actually an EU citizen. I was born in Ireland. I moved to San Francisco when I was 6. I came back to Ireland and did my law school at Trinity College in Dublin, and I worked in Europe for over 15 years, all over Europe. And so I'm not representing the US right now. I do have a US passport as well, so I look at both countries. But what I'm going to talk about today is a little bit. So I'm going to talk a little bit different about what you've heard all day today. You've heard about the cloud, you've heard a lot about security, you've heard a lot about transparency. I'm going to take it in a different level. I am not anti-cloud, so you need to know that going in. Don't walk out this door saying Sheila said you should not move to the cloud, because that's not what I'm saying. The cloud is the direction of the future, but there are some concerns you need to think about that normally do not get addressed. And it's the changes in data privacy and sovereignty laws. Whether it's the new General Data Protection Regulation going into effect in 2018, whether it's the fact that Brexit, the UK may possibly be leaving the EU. Does that mean your personal data cannot be stored in the UK? That's a consideration you have to look at. Is it the negotiation of the privacy shield that's going on between the US and the EU right now? Or is it the fact that the US Supreme Court just ruled that they have the right to access any data on any individual in any jurisdiction in the world without a subpoena if they're doing an investigation? So that's kind of concerning. So if I can figure out how to move forward. So all of a sudden, privacy laws have been in place for a long time. They've been in place a lot longer than I've been doing this, and I've been doing this for over 35 years. I've been a privacy attorney. Someone in Europe last week in London told me I was very old in front of about 300 people. So that didn't make me feel too good. But these laws have been in place for a very long time. And because of the change in technology and the change of business model, whether it's big data, whether it's the cloud, the need to pay attention to data privacy and data sovereignty laws has become a lot more important. So when you think about it, you know, if you think about just the EU itself, you have to look at the laws at different levels. You have to look, if you operate within France, you need to look at the French data protection regulations. But in addition to that, you also need to look at the EU data privacy or data protection directive that is going to be replaced with a more enhanced General Data Protection Regulation, and I do have a slide on that, so I will talk about it. You need to think about what are the issues around data sovereignty. Is personal data allowed to be stored or hosted outside of the country of origination? Can you move your data to the US that offers inadequate protection when it comes to data privacy? Can you move European data to Asia Pacific? What do the laws there look like? Can you move French data to the UK? Can you move German data to France? These are all the issues that you need to consider before you think about moving to the cloud. You just can't think about security alone and think that you have built a world-class program. Steve talked a lot about the trusted advisor role, which is extremely important. But part of that trusted advisor role is also looking at the data and what data you're using and what data you're accessing and what laws apply to that data that allow you to collect, process, use, access, or store data in a particular environment. So most of if we just talk briefly about the GDPR, I'm not going to go into great detail about it, but if you ever have insomnia and want to call me, I'm happy to discuss it at about 3 in the morning, and I will put you to sleep very quickly. But this is a very aggressive law. It's a massive change in the way you can collect, use, and process personal data. It will impact every organization, regardless of whether or not you have operations in Europe. So if you have access to the personal data of any European citizen, even if you do not have a presence here, you will have to comply with the new regulation. And if you violate the regulation, the sanction can be up to 4% of your global annual revenue. Now, I personally would not want to go to the CEO of NetApp and tell George that he has to write a check for 4% of our global annual revenue. That could be in the billions. So the new regulation is going to be quite extensive. And it's going to be particularly have an impact on service providers and cloud providers. Because traditionally, if you hosted data on behalf of a company, but you weren't really processing that data, or you didn't have access to that data, you didn't have to comply with many of the data privacy regulations. That changes under GDPR. If you host the data, even if you do not have access to that data, you will have to comply with the regulation. So the laws are definitely changing, and you need to look at them. If you think about the US, most of probably of the big cloud providers that you deal with, or service providers that you deal with, are based in the US. And as I said earlier, the US has the least restrictive data privacy laws. The US government actually sells the personal data of US citizens to telemarketers and financial institutions. Drives me insane. Don't ever call my house offering me a free credit card because you have my personal data, because you'll get an earful. But it's not that the US doesn't take privacy seriously. It's just a different mindset than when you see in the rest of the world. So in the US, the mentality is more of a business-generated mentality. We think about technology. We think about innovation. We think about the future. We think about security. But we really don't think about privacy, because the Constitution in the US is based on freedom of information, where elsewhere in the world, it's that fundamental right to privacy. So when you're dealing with a US company, you need to make sure you are vetting that company for how they comply with the laws in France, in Europe, in any other jurisdiction in which you operate. It is very, very important. You can't just ask the question, do you comply with privacy laws? You have to ask that question, how do you comply with privacy laws? And there's a big difference. And one of the answers can't be, we comply with the laws in the jurisdiction where we have processing centers. That is very different than saying, we comply with the laws in every jurisdiction in which you operate. So it's very important that you ask the right questions. So how many of you have heard about the Privacy Shield that's being negotiated? Okay, a few of you have heard about it. With full disclosure, I was actually one of the attorneys on the EU side negotiating against the US. I'm not a big fan of Privacy Shield. I was never a fan of Safe Harbor. We will know Monday what's going to happen. But even if Privacy Shield does get approved, there is a strong probability that when GDPR goes into effect, it will be once again invalidated. And so that's something that you really want to pay attention to, especially if you work with a company that relies on Privacy Shield as their privacy framework. And what about Brexit? So everyone's talking. I was in Europe actually the day the vote happened, and many of my customers actually asked me how I influenced it so that that UK would leave, because it would actually add to more of the privacy issues that I get to discuss. One of the things that we're going to have to look at is if you store data in the UK, or you have access to data of UK residents, which laws are going to apply? If you are a provider that has your data center in the UK, are you going to be allowed to move European data? If you happen to be a resident of Northern Ireland and you work in the Republic of Ireland, are you going to have to get a visa or a work permit now to work within the EU? You could be 1 mile down the road from the border and have to get a work permit. So there's going to be major issues, and it is going to impact the data privacy obligations. The UK will have to comply with GDPR. So challenges in the world of cloud computing. So, again, cloud is the direction of the future. I am not anti-cloud by any means. But if you're only making your decision to move to the cloud based on productivity, flexibility, scalability, the ability to downsize your IT organization and move a lot of your processes to a cloud, you are missing one of the primary things you need to look at, and that is data privacy. What are the regulations around moving data? What jurisdiction? What law applies? Even if the data center is in, say, France, where is that data backed up and replicated? Are you even asking those questions of the cloud provider? What third party does your cloud provider use in order to support their environment? So even though the data center may be located in France, does your cloud provider manage that data center, or do they outsource to a third party? I'm not saying that's a bad thing, but what I'm saying is you need to ask the question of how does your cloud provider, as well as their third-party providers, comply with the French Data Protection Act, the GDPR, and all of the data privacy laws in every jurisdiction in which you operate. Where does that data flow through before it even gets to the data center? So is it flowing through a jurisdiction outside of France before it even gets there? What role does your cloud provider play? Are they the data controller or are they the data processor? So if you're the customer and you're making the decision to move your data to the cloud, you are the data controller. You define how your data can be used, who can have access to it, where it can be stored, where it can be replicated, what happens if there's a disaster, what the disaster recovery plan is, what happens if there's a security breach, who owns it. Your cloud provider is the data processor. They follow your direction. And as I said earlier, under the new law, they will have to comply with the new regulation that holds them accountable for privacy violations and security violations. But if your cloud provider outsources their data center or any of the services to a third party, your cloud provider has in effect become a data controller. So they're now a co-data controller, but yet you as the customer have sole liability for any data privacy or security violations if you did not negotiate in the contract up front. You need to ask the question, what role do they play? What data am I going to put in that environment? And Steve talked a lot about the assessment. Absolutely doing an assessment is critical. I look at it as a little bit of a different assessment. I look at it as a privacy impact assessment. I'm a slide ahead, so let me talk about a privacy impact assessment to start with. Before you even make the decision to move to the cloud, you need to assess what data you have, not from an IT infrastructure. Everybody always looks at it from tier 1, tier 2, tier 3. And you say, well, tier 3 that's not very, I mean, that won't harm the company if we put the tier 3 data into a cloud environment or we outsource it to a third party. But tier 1 data might be the crown jewels of the company. We're going to be a little careful putting that into the hands of a third party. The problem is when you do it that way, some of your most personal and sensitive information on your employees, your customers, your suppliers may be in a tier 3 application. So you need to classify your data based on the type of data it is and what laws apply to that data, what jurisdictions apply. You need to conduct a privacy impact assessment to determine what type of data it is, what type of cloud environment makes sense. Is it public? Is it private? Is it hybrid? You need to determine what the role is of each of the providers and how they comply with data privacy laws. So conducting a privacy impact assessment is extremely important. And now I'll address this. This is always my favorite topic. I love when I talk to companies and they say, we have world-class security, therefore we've covered our privacy obligations. Privacy and security are intertwined, but they are absolutely not the same thing. You can have world-class security and absolutely no privacy. So if you think of privacy as the wheel, it's the data. It's the full life cycle of the data. What you collect, what you do with that data, what laws protect it, who can have access to it, where you can store it, can you transfer it outside of the country of origination. Security is the fortress around that data. So if you think of privacy as the wheel, security is one spoke on that wheel. And if you're only looking at that one spoke, that wheel's going to break. Security is extremely important because you need to lock down that data. But if all you're doing is encrypting data that you never should have had to begin with because you didn't comply with your privacy obligations, encryption is not going to help you. So you need to look at privacy as the full life cycle and security as one extremely important component of that data. And if you talk to a supplier or provider and you ask them about their privacy program and they give you a security answer, you have a problem because they do not understand privacy. So if you ask a supplier, how do you comply with your privacy obligations in France? And they say, we're ISO 27018 compliant. My advice to you is run, because what they're giving you is a security certification for the cloud and not a privacy certification. So that's very important to understand the difference. So how do you mitigate the risks? Again, not telling you not to move to the cloud, but you need to understand what data you're working with. You need to understand what laws protect that data. Where is that data going to be located? If the data center is in Europe, where is that data going to be backed up and replicated? What third party is going to have access to that data? If you don't need to collect personal data, don't collect it. Use aggregate, statistical, or anonymous data wherever possible. Conduct a privacy impact assessment. If you don't know what that looks like, let me know. NetApp, we've built some incredible tools around conducting privacy impact assessments at questions that you need to ask a cloud provider from a data privacy and a data sovereignty point of view, as opposed to purely security. When the data can remain in country, keep it in country. If it doesn't need to remain in country and you've gone through the compliance process, then absolutely move it to whatever jurisdiction makes sense for you. Again, I'm not saying you can't move the data. You just need to do your due diligence before you move that data. Make sure you define who owns the data and what the role of every party involved is, and what agreements are in place, and what visibility are you as the customer going to have to your cloud providers, third-party providers. That's extremely important, because if your cloud provider uses subcontractors and that subcontractor has a privacy violation, who's going to be held accountable? And if you didn't negotiate that up front and you didn't ask the question, you as the customer are going to have sole liability. And remember, with the new regulation, that could be 4% of your annual global revenue. So it's very important that you ask the question. Okay, how am I doing on time? This is normally an hour presentation, and I love to talk, so I'm doing it really fast. This just as an example, NetApp, what I didn't mention earlier is we've been identified as a company of excellence for data privacy compliance. We're one of only 100 companies worldwide that has achieved binding corporate rule status. That's the highest level of compliance you can achieve. And it means that every jurisdiction within Europe, every one of the 28 member states has deemed NetApp to be adequate when it comes to data privacy compliance. It is a very aggressive, robust program we put in place, but we have the same issues you do. We have to collect data, we have to store data, we have to mitigate our risks, we need to take advantage of new technology, and we need to manage our costs. So the program that I built 9 years ago is a global program. I based it on the 3 most restrictive jurisdictions, Germany, Hong Kong, and New Zealand. And so when the program was built to meet those regulations, we can meet the regulations in every country around the world. And 65 countries have identified NetApp as being world-class when it comes to privacy. And so what we do is I take the model that I built that involves not only policies and procedures, but working with our technology organization, our product ops organization, and our partners, and defining what products and what solutions need to look like from a privacy and data sovereignty point of view. And then we can take that program and help our customers understand their legal obligations and their compliance when it pertains to privacy and sovereignty, big data, cloud computing, Internet of Things, whatever the issue is. But if you'd like to know more about the program, just let me know. So my last slide is really talking about this intersection of trust and technology. It goes back again to what Steve said just a little while ago, that importance of the trusted advisor. You need to find someone that can help you navigate through the challenges of putting data in a cloud from a data privacy and a data sovereignty perspective. You need to embrace the law. Don't run from it. I'm always amazed when companies come to me and they'll say, what's the least amount of work I have to do to comply with the laws? Or what can I do to get around having to comply with data privacy laws? You will spend more time and energy trying to figure out how to get around the laws than you will if you just embrace them and deal with it. It's much easier that way. Understand your legal requirements going in. Understand the difference between privacy and security. Again, not the same thing. Understand what your risk tolerance is. You may not be a regulated industry. You may have a very high risk tolerance, or you may have a very low risk tolerance. It really depends on your organization, but you need to understand that going in. And most importantly, find a trusted advisor. Find someone who can guide you and help you through these challenges. They're not going to tell you not to move to the cloud. Absolutely not. The cloud is the direction of the future. That's the direction we're all going in. But again, you can't just make the decision based on, cost, flexibility, scalability. You have to put privacy and sovereignty into that equation. So I think I actually got through that, believe it or not, in 15 minutes. That's a shock. So thank you very much.